Health rules, TPS and DNA checks, new immigration shifts 2025. This week, the tone is serious. 3 major updates are reshaping the U.S. immigration landscape, and each one could directly affect how future applicants are judged, processed, and tracked. We're talking about the reported new health-based visa denials under public charge rules, the end of temporary protected status, TPS, for South Sudan, and a proposed DNA and biometric expansion rule that could collect more personal data than ever before. Some of these updates are controversial. Some are quietly being implemented behind the scenes. But all deserve your attention because they're changing how America screens and manages immigration. Let's break it all down. New public charge health rule. Medical conditions under review. For years, public charge has meant one thing: whether an immigrant is likely to depend on U.S. government assistance. But according to recent reports, the Trump administration has now instructed U.S. consular officers to consider specific medical conditions as part of that determination. That includes obesity, diabetes, heart and cardiovascular diseases, cancer, and mental health conditions. In plain terms, your medical background could now play a bigger role in whether you get a visa. The directive, reportedly sent to U.S. embassies worldwide, advises officers to deny immigrant visas to applicants who may pose a likely future burden on the American healthcare system. While the exact language of the guidance has not been made public, multiple immigration attorneys have confirmed embassy staff are referencing it during interviews. The move effectively broadens the public charge rule from being about financial stability to now including personal health. Why this is controversial? Under long-standing U.S. immigration law, officers are not supposed to deny a visa based on what might happen in the future. They are required to assess actual evidence, not speculative what-ifs. The State Department's own rules say visa decisions cannot rely on assumptions about future medical costs or potential illness. So this shift raises serious legal and ethical questions. Critics say it risks discriminating against older adults, people with disabilities, those with chronic illnesses who manage their conditions responsibly. Supporters, however, argue that the U.S. has the right to ensure newcomers are self-sufficient and able to cover their healthcare costs without public support. It's a debate about fairness versus protection, and right now, that debate is unfolding quietly in embassies worldwide. Immigration advocates warn this could result in a wave of unexplained medical denials, especially for applicants from developing countries with higher rates of chronic illness. What applicants can do. If you're applying for an immigrant visa or green card soon, here's what you can do to strengthen your case. Bring comprehensive medical documentation, including treatment records showing your condition is managed and stable. If you have insurance coverage, include proof of active policy and financial ability to cover your healthcare. Consider attaching a doctor's letter verifying you're fit to work, travel, and live independently. These steps can't override policy, but they help show that you're not a public charge risk, and that's exactly what officers are looking for. The key takeaway: don't hide a condition. Present it transparently and show evidence that it's controlled, affordable, and responsibly managed. TPS for South Sudan, ending January 5th, 2026. Let's move to the next major change, the end of temporary protected status, or TPS, for nationals of South Sudan. The Department of Homeland Security, DHS, has officially announced that TPS protections for South Sudan will end on January 5th, 2026. This means that nationals currently protected under TPS must either adjust their status through another immigration pathway or prepare for return once the program expires. The decision has drawn criticism from humanitarian groups, especially given ongoing instability, displacement, and conflict in parts of South Sudan. For years, TPS has allowed South Sudanese nationals to legally live and work in the U.S. due to unsafe conditions back home. Now, with the administration determining that conditions have improved sufficiently, those protections will be phased out. What affected individuals should know. TPS holders from South Sudan are protected until January 5th, 2026. Work permits under TPS remain valid until that date. DHS will publish wind-down procedures, explaining how to maintain lawful presence during the transition. However, if your TPS status expires and you do not hold another visa or application in process, you could face removal once the grace period ends. Immigration attorneys are urging South Sudanese nationals to act early, explore family petitions, student visas, or asylum options before the final date arrives. The key message: do not wait until 2026 to plan your next step. New DNA and biometric expansion. Privacy under the microscope. Now, let's talk about something far bigger than any single policy, a proposed federal rule that could transform how the government collects immigration data. The Department of Homeland Security, DHS, has proposed expanding biometric collection to include DNA samples, voice prints, iris scans, and facial and behavioral data for both immigrants and their sponsors. In other words, not just the applicants, but also the U.S. citizens or permanent residents sponsoring them could have their biometric data permanently stored. This would be one of the largest data expansions in immigration history. The stated goal: to improve identity verification, prevent fraud, and modernize national security screening. However, privacy experts argue that the rule gives DHS unprecedented access to personal data, raising questions about how long DNA information will be stored, how it can be used, and whether it can ever be deleted. Public response and comment deadline. The proposed rule is currently open for public comment until January 2nd, 2026. This means anyone, individuals, lawyers, or organizations, can submit feedback directly to DHS before it's finalized. Public comments matter. In past cases, strong opposition has led to revisions or delays in major policy rollouts. So, if you're concerned about privacy, data security, or consent, this is the time to speak up. You can find the comment submission link on Regulations.gov by searching DHS Biometric Rule Public Comment. Why this matters? When combined, these three developments show the broader direction of U.S. immigration policy. More screening, more data, more personal evaluation from your health to your DNA. For applicants, it's a reminder to prepare thoroughly. For sponsors, it's a sign to understand what information you're sharing and how it might be stored. And for everyone watching immigration closely, it's proof that the system is shifting from paper and interviews to digital profiles and predictive assessments. Technology is becoming the new border. If you like this video, don't forget to hit like, subscribe, and turn on the bell icon for future updates. Thanks for watching. See you in the next video.